Question 1. Topic: Freedom of speech, incitement and the Brandenburg test. In a high-stakes environment where multiple challenges arise in balancing public order and free speech, a political activist delivers a speech at a public rally calling for resistance against government policies. The speech includes statements such as, "We need to fight back against this corrupt system, and it's time for action before they take away our rights." Late evening, some members of the audience vandalize government buildings. The activist is charged with incitement to violence. Under the Brandenburg test, which factor would be most critical in determining whether the activist's speech is constitutionally protected? A. Whether the speech contained inflammatory language. B. Whether the speaker had history of advocating violence. C. Whether the speech was directed to inciting imminent lawless action and was likely to produce such action. D. Whether audience members engaged in criminal acts after the speech. Answer: C. Whether the speech was directed to inciting imminent lawless action and was likely to produce such action. Explanation: The Brandenburg v. Ohio 1969 test sets the standard for incitement. Speech can only be punished as incitement if 1. It is directed to inciting or producing imminent lawless action, and 2. It is likely to incite or produce such action. Optional is incorrect. While inflammatory language may be relevant, the Brandenburg test requires more than just heated rhetoric. It must advocate immediate illegal action. Option B, incorrect. A speaker's past advocacy of violence is not determinative. The key issue is whether the specific speech in question meets the Brandenburg standard. Option C, correct. The court must determine if the speech specifically called for imminent illegal activity and whether it was likely to lead to such action. Option D, incorrect. While audience reaction is relevant, criminal acts occurring afterward do not automatically prove incitement unless they were directly caused by the speaker's words. This case highlights the strict constitutional limits on government suppression of political speech. Even strong rhetoric remains protected unless it meets Brandenburg's stringent criteria. Question 2. Topic: Freedom of religion, establishment clause, and school prayer. During a comprehensive review of a process that needs improvement, a public school district revises its morning announcements policy. The new policy allows teachers to begin each day with a moment of silence, during which students may pray, meditate, or reflect quietly. A group of parents challenges this policy, arguing that it violates the Establishment Clause. First Amendment. What is the most important constitutional question the court must address? A. Whether the policy explicitly endorses religious prayer over secular reflection. B. Whether the school has historically allowed similar practices. C. Whether students feel social pressure to participate in religious activity. D. Answer: A. Whether the policy explicitly endorses religious prayer over secular reflection. Explanation: Under the Establishment Clause of the First Amendment, the government cannot endorse, promote, or coerce participation in religious activities in public schools. Option was all correct. The key issue is whether the school's moment of silence promotes religious prayer over secular reflection. In Wallace v. Jaffrey, 1985, the Supreme Court struck down moment of silence law that explicitly encouraged prayer, finding it unconstitutional. However, truly neutral moment of silence may be permissible. Option B, incorrect. Historical precedent does not automatically validate practice if it violates the Establishment Clause. Option C, incorrect. While social pressure is a relevant factor, as in Levi-Weissman 1992, the central issue here is whether the policy itself advances religion. Option D, incorrect. The ability to leave the room does not cure policy that improperly promotes religion. In Santa Fe Independent School District v. Doe 2000, the court ruled that even student-led prayers at football games were unconstitutional due to the school's involvement. This question illustrates the Lemon test, Lemon v. Kurtzman 1971, which courts used to analyze Establishment Clause violations. The law, secular legislative purpose. The law's primary effect must neither advance nor inhibit religion. The law must not foster excessive government entanglement with religion. Question 3. Topic: Freedom of the press, defamation, and public figures. While investigating inconsistencies across various units in a government agency, a well-known journalist publishes an article alleging that the U.S. senator has accepted illegal bribes from a foreign government. The article is based on anonymous sources and lacks direct evidence. The senator sues for defamation, arguing that the accusations are false and damaging. What is the senator required to prove in order to succeed in the lawsuit? A. That the journalist published the article with actual malice, meaning they knew it was false or acted with reckless disregard for the truth. B. That the article contained factual inaccuracies and harmed the senator's reputation. C. That the journalist failed to verify all claims with government records before publication. D. That the public reacted negatively to the article and the senator's reputation suffered as a result. Answer: A. That the journalist published the article with actual malice, meaning they knew it was false or acted with reckless disregard for the truth. Explanation: the landmark case New York Times v. Sullivan, 1964, established the actual malice standard for defamation claims brought by public officials. This means that public official or public figure must prove that false statements were published with knowledge of their falsity or reckless disregard for the truth. Option correct: the senator must show actual malice, meaning the journalist either knew the information was false or published it with reckless disregard for whether it was true or false. This is high legal bar designed to protect robust political journalism and prevent self-censorship. Option B incorrect. Simply proving factual inaccuracies and reputational harm is insufficient for public officials. Private individuals, however, only need to prove negligence. Option C incorrect. While responsible journalism involves verifying sources, the First Amendment does not require journalists to confirm all claims with official records before publication. Option D incorrect. Public reaction is irrelevant unless actual malice can be demonstrated. This case underscores the strong constitutional protections for press freedom, allowing journalists to report aggressively on public officials without fear of liability unless they act with actual malice. Question 4. While analyzing the root causes of sequential problems in government regulations affecting free speech, a legal dispute arises concerning the application of the Brandenburg test to online speech. A social media influencer, known for making provocative statements, posts a video encouraging their followers to resist government tyranny by protesting at government buildings. The video does not explicitly instruct followers to engage in violence, but some commenters interpret the message as call for physical action. 2 days later, several individuals are arrested for attempting to storm City Hall, claiming they were inspired by the video. The government prosecutes the influencer for incitement. Under current First Amendment jurisprudence, would the influencer's speech be protected? A yes, because political speech is given the highest level of protection under the First Amendment. B no, because the speech encouraged illegal activity, which is not protected under Brandenburg. C yes, because there was no direct incitement to imminent lawless action as required by Brandenburg. D no, because courts apply a lower standard of protection for online speech. Answer: C yes, because there was no direct incitement to imminent lawless action as required by Brandenburg. Explanation: the Brandenburg test, Brandenburg v. Ohio, 1969, establishes that speech can only be punished as incitement if it meets 2 criteria. 1. The speech is directed to inciting or producing imminent lawless action, and 2. The speech is likely to produce such action. Here the influencer's video contains language encouraging resistance but does not explicitly call for immediate unlawful behavior without direct imminent call to violence. The government is unlikely to meet its burden under Brandenburg. Answer: B is incorrect because merely encouraging resistance does not automatically constitute illegal incitement unless the imminence requirement is met. Answer: D is incorrect because online speech is generally evaluated under the same First Amendment standards as other speech. Question 5. In a high-stakes environment where multiple challenges affect freedom of the press, a government agency denies a newspaper access to classified documents about a military operation. A whistleblower leaks the documents, and the newspaper plans to publish them, arguing that public interest outweighs national security concerns. The government seeks an injunction to prevent publication, citing the risk of severe diplomatic consequences. Based on Supreme Court precedent, how should the court rule? A. Grant the injunction because national security concerns justify prior restraint in cases involving classified materials. B. Deny the injunction because the government has a high burden to justify prior restraint, which it has not met. C. Grant the injunction because leaking classified materials is a criminal offense and publishing them aids in unlawful activity. D. Deny the injunction because the First Amendment provides an absolute to publish all government information. Answer: B. Deny the injunction because the government has a high burden to justify prior restraint, which it has not met. Explanation: the Supreme Court case New York Times Company v. United States, 1971, the Pentagon Papers case established that prior restraint, preventing publication before it occurs, is almost always unconstitutional unless the government meets a heavy burden of proving an extreme threat to security. The government cannot simply claim harm It must demonstrate direct, immediate, and irreparable damage. And answer A is incorrect because courts are extremely reluctant to allow prior restraints, even in national security cases. Answer C is incorrect because while leaking classified documents is a crime, publishing them is protected unless it meets the strict standard for prior restraint. Answer D is incorrect because the First Amendment is not absolute. Certain categories of speech, such as true threats and incitement, can be restricted. Question 6. While investigating a complicated issue between different legal standards on hate speech, a state university enacts a policy prohibiting offensive and insensitive speech on campus. A student group invites a controversial speaker who criticizes a particular religious community, leading to protests. The university cancels the event, citing the need to maintain an inclusive environment. The student group sues, claiming violation of their First Amendment rights. What is the most likely outcome? A. The university's policy is unconstitutional because it is vague and overbroad restriction on speech. B. The university can restrict the speech because hate speech is not protected under the First Amendment. C. The university's interest in maintaining an inclusive environment outweighs the student's right to host the speaker. D. The university can regulate speech on campus without First Amendment concerns because it is not government entity. Answer A. The university's policy is unconstitutional because it is vague and overbroad restriction on speech. Explanation: government restrictions on speech must be precise and narrowly tailored. The Supreme Court has consistently struck down vague and overbroad speech restrictions. CR AV City of St. Paul, 1992. Hate speech, while offensive, is generally protected under the First Amendment unless it falls under an unprotected category like incitement, fighting words, or true threats. Answer B is incorrect because the US does not have categorical ban on hate speech. Answer C is incorrect because public universities are bound by the First Amendment and cannot suppress speech simply because it is offensive. Answer D is incorrect because state universities are government actors and must comply with First Amendment protections. Question 7. During an emergency response where multiple areas are impacted by civil unrest, a mayor issues a temporary order prohibiting public protests in front of City Hall, citing safety concerns. Protesters challenge the order as an unconstitutional restriction on their right to assemble. How should the court rule? A. The order is valid as a time, place, and manner restriction as long as it is content neutral and narrowly tailored. B. The order is unconstitutional because the government cannot prohibit protests in any location. C. The order is constitutional because public safety concerns override First Amendment rights. D. The order is unconstitutional because emergency situations cannot justify restrictions on speech. Answer A. The order is valid as a time, place, and manner restriction as long as it is content neutral and narrowly tailored. Explanation: government regulations on assembly must meet the time, place, and manner test, meaning they must be content neutral, serve a significant government interest, and leave ample alternative channels for expression. Ward v. Rock against Racism, 1989. Here, a temporary restriction due to safety concerns may be held if it meets these criteria. Answer B is incorrect because the government can impose reasonable time, place, and manner restrictions. Answer C is incorrect because public safety does not automatically override First Amendment rights. The restriction must be narrowly tailored. Answer D is incorrect because emergency situations can justify some restrictions, but they must still comply with constitutional standards. Question 8. While examining the challenges faced by law enforcement in balancing public safety and constitutional rights, a police department implements a policy allowing officers to stop and search any individual in high-crime areas without specific suspicion. A citizen who is searched under this policy sues, arguing that it violates the Fourth Amendment's protection against unreasonable searches and seizures. How should the court rule? A. The policy is unconstitutional because it allows searches without reasonable suspicion. B. The policy is constitutional because law enforcement can conduct searches in high-crime areas. C. The policy is unconstitutional unless officers obtain warrant before conducting searches. D. The policy is constitutional because public safety concerns justify warrantless searches. Answer A. The policy is unconstitutional because it allows searches without reasonable suspicion. Explanation: the Fourth Amendment protects individuals from unreasonable searches and seizures. In Terry v. Ohio, 1968, the Supreme Court established that police officers may briefly stop and frisk individuals based on reasonable suspicion, but they cannot conduct searches without some level of individualized suspicion. is policy. Likely unconstitutional because it allows officers to conduct suspicionless searches solely based on an individual's presence in high crime area. The Supreme Court has ruled in Illinois v. Wardlow 2000 that being in high crime area by itself does not justify search. Therefore, answer B is incorrect because law enforcement needs reasonable suspicion to search individuals even in high crime areas. Answer C is incorrect because not all searches require warrant, but they must meet legal standard like probable cause or reasonable suspicion. Answer D is incorrect because public safety concerns alone do not override constitutional protections. Question 9. In a high-stakes decision involving conflicts between public health mandates and individual liberties, a state legislature passes a law requiring all employees in the state to be vaccinated against a newly emerging virus. Several employees refuse to comply, citing personal and religious objections. They sue the state, arguing that the mandate violates their rights under the First and 14th Amendments. How should the court rule? A. The law is unconstitutional because it violates the First Amendment's protection of religious freedom. B. The law is constitutional because states have broad authority to regulate public health. C. The law is unconstitutional because medical decisions are fundamental personal right under the 14th Amendment. D. The law is constitutional only if there are no alternative public health measures available. Answer B. The law is constitutional because states have broad authority to regulate public health. Explanation. The Supreme Court has long upheld the government's power to enforce public health measures even when they infringe on individual liberties. In Jacobson v. Massachusetts, 1905, the court ruled that states can mandate vaccinations to protect public health. This precedent was reaffirmed in Zutt v. King, 1922. Upheld school vaccination requirements. Religious objections do not automatically exempt individuals from public health mandates, as seen in Employment Division v. Smith, 1990, where the court ruled that neutral, generally applicable laws do not violate the free exercise clause. Answer A is incorrect because the law applies equally to all employees and does not target any religion. Answer C is incorrect because while the 14th Amendment protects personal liberties, the government's compelling interest in preventing disease outweighs individual objections. Answer D is incorrect because courts do not require states to prove there are no other alternatives, only that the mandate is reasonable. Question 10. While investigating a complex legal issue involving discrimination in private businesses, a baker refuses to create a custom wedding cake for a same-sex couple, citing religious beliefs. The couple sues under state anti-discrimination laws that prohibit businesses from refusing service based on sexual orientation. The baker argues that being forced to create the cake violates their First Amendment rights to free speech and exercise. How should the court rule? A. The baker's refusal is unconstitutional because public businesses cannot discriminate based on sexual orientation. B. The baker's refusal is constitutional because forcing them to create cake violates their free speech rights. C. The baker's refusal is unconstitutional because religious beliefs do not exempt businesses from anti-discrimination laws. D. The baker's refusal is constitutional because private businesses have absolute freedom to choose their customers. Answer B. The baker's refusal is constitutional because forcing them to create cake violates their free speech rights. Explanation. In Masterpiece Cake Shop v. Colorado Civil Rights Commission 2018, the Supreme Court ruled in favor of the baker, emphasizing that compelled speech, forcing someone to create expressive content against their beliefs, violates the First Amendment. However, the ruling was narrow, focusing on the government's hostility toward the baker's religious beliefs rather than a broad right to discriminate. Answer A is incorrect because the case centered on free speech, not just discrimination laws. Answer C is incorrect because while businesses must generally follow anti-discrimination laws, the court made an exception for expressive products like custom cakes. Answer D is incorrect because businesses do not have an absolute right to refuse service in all cases. Civil rights laws still apply. Question 11. While considering the legal responsibilities of businesses in product liability cases, a company releases a new model of electric scooters. After several accidents caused by sudden brake failures, customers sue the company for injuries. The company argues that it properly tested the scooters before selling them. Under what legal principle might the company still be held liable? A. The company is liable only if it was negligent in testing the scooters. B. The company is strictly liable for defects that make the product unreasonably dangerous. C. The company is not liable if it provided a warning about potential brake issues. D. The company is liable only if it intentionally sold defective scooters. Answer B. The company is strictly liable for defects that make the product unreasonably dangerous. Explanation: under strict liability and product liability law, a company can be held responsible for defects regardless of negligence. The key issue is whether the product was unreasonably dangerous due to a design defect, manufacturing defect, or failure to warn. In Greenman v. Uber Power Products, 1963, the court that manufacturers are strictly liable when a product causes injury due to defects. Answer A is incorrect because strict liability does not require proof of negligence. Answer C is incorrect because warnings are not a defense if the defect makes the product inherently dangerous. Answer D is incorrect because liability applies even if the company did not intend to sell defective scooters. Question 12. When examining the constitutional limitations on government surveillance, Congress passes a law allowing law enforcement to access private emails without a warrant. A privacy advocacy group challenges the law, arguing that it violates the Fourth Amendment. What constitutional principle is at stake? A. The law is unconstitutional because the Fourth Amendment protects electronic communications. B. The law is constitutional because emails are voluntarily shared with service providers. C. The law is unconstitutional only if the emails contain sensitive personal information. D. The law is constitutional if it is used for national security purposes. Answer A. The law is unconstitutional because the Fourth Amendment protects electronic communications. Explanation: the Fourth Amendment protects individuals from unreasonable searches and seizures, and this protection extends to digital privacy. In Carpenter v. United States 2018, the Supreme Court ruled that the government needs a warrant to access cell phone location data. Similarly, accessing private emails without a warrant violate reasonable expectation of privacy. Answer B is incorrect because courts have ruled that digital communications have an expectation of privacy. Answer C is incorrect because constitutional protections apply to all content, not just sensitive data. Answer D is incorrect because even national security laws must comply with constitutional safeguards. Question 13. While analyzing the ethical considerations in artificial intelligence, a social media company develops an AI that can predict user behavior and modify content recommendations accordingly. Critics argue that this technology manipulates users and infringes on their autonomy. What ethical concerns arise from this AI system? A. The AI raises ethical concerns related to informed consent and manipulation. B. The AI is ethical because users voluntarily engage with the platform. C. The AI raises no ethical concerns as long as it improves user experience. D. The AI is unethical only if it causes financial harm to users. Answer A. The AI raises ethical concerns related to informed consent and manipulation. Explanation: ethical concerns in AI include autonomy, informed consent, and manipulation. If an AI system alters user behavior without explicit consent, it can be seen as a violation of autonomy. Studies have shown that AI-driven content recommendation can lead to filter bubbles and addictive behavior, raising ethical red flags. Answer B is incorrect because voluntary engagement does not negate concerns about manipulation. Answer C is incorrect because ethical issues extend beyond user experience. Answer D is incorrect because ethical concerns exist even if no financial harm occurs. Question 14. During a comprehensive review of a process that needs improvement, a public university creates a policy requiring all student organizations to accept any student as a member regardless of their beliefs. A religious student group challenges the policy, arguing that it forces them to accept members who do not share their religious views and thus violates their First Amendment rights. What is the most relevant legal precedent? In this case, the policy is unconstitutional because it violates the religious group's right to freedom of association. B. The policy is constitutional because public universities can impose viewpoint-neutral regulations on student groups. C. The policy is unconstitutional because it treats religious groups differently from secular groups. D. The policy is constitutional because student organizations are not protected by the First Amendment. Answer B. The policy is constitutional because public universities can impose viewpoint-neutral regulations on student groups. Explanation: in Christian Legal Society v. Martinez 2010, the Supreme Court ruled that a public university can require student organizations to follow an all-comers policy as long as it is viewpoint neutral. The court held that this does not violate the First Amendment because the university's policy applied equally to all groups and did not target religious organizations specifically. Answer is incorrect because while freedom of association is protected, public universities can impose reasonable viewpoint-neutral regulations on student organizations. Answer C is incorrect because the policy applies to all groups equally. If it specifically targeted religious groups, it would likely be unconstitutional. Answer D is incorrect because student organizations do have First Amendment protections, but those rights are balanced against the university's interest in non-discrimination. This case highlights the tension between free association and anti-discrimination principles in public institutions. Question 15. In a situation where formal requirements conflict with free speech protections, a city council passes an ordinance requiring protest groups to obtain a permit before demonstrating in public parks. A local activist refuses to apply for a permit and holds a protest without one. The city finds the activist, who challenges the ordinance, as unconstitutional. How should the court rule? A. The ordinance is unconstitutional because requiring a permit violates the right to assemble. B. The ordinance is constitutional as a valid time, place, and manner restriction. C. The ordinance is unconstitutional because cities cannot regulate speech in public parks. D. The ordinance is constitutional only if it applies to political protests and commercial events equally. Answer B. The ordinance is constitutional as a valid time, place, and manner restriction. Explanation. Governments can impose time, place, and manner restrictions on speech in public forums as long as they are content neutral, not based on the speaker's viewpoint, narrowly tailored to serve significant government interest, and leave open ample alternative channels for communication. Ward v. Rock against Racism, 1989. Answer A is incorrect because the right to assemble is not absolute. Reasonable restrictions can apply. Answer C is incorrect because cities can regulate how speech occurs in public parks. Answer D is incorrect because while neutrality is required, the key issue is whether the rule is narrowly tailored and serves legitimate government interest. Question 16. When improving a process that shows unexpected results, a state government requires social media companies to remove false or misleading political content. A company challenges the law, arguing that it violates its First Amendment rights. What is the most likely outcome? A. The law is unconstitutional because it compels private companies to regulate speech. B. The law is constitutional because social media platforms are not protected by the First Amendment. C. The law is unconstitutional only if it applies to news organizations as well. D. The law is constitutional because misinformation is not protected speech. Answer A. The law is unconstitutional because it compels private companies to regulate speech. Explanation. The First Amendment limits government action, not the actions of private companies. However, when the government mandates private entities to remove content, it violates the prohibition against compelled speech. Miami Herald v. Tornillo, 1974. Answer B is incorrect because private companies do have free speech rights. Answer C is incorrect because the law's constitutionality is not dependent on whether it applies to news organizations. Answer D is incorrect because false speech is generally protected except for defamation, fraud, or incitement. Question 17. While analyzing inconsistencies across various units in free speech cases, a state prohibits burning the national flag. A protester is arrested for violating the law and argues that their actions are protected symbolic speech. How should the court rule? A. The law is unconstitutional because flag burning is protected symbolic speech. B. The law is constitutional because the government has an interest in protecting national symbols. C. The law is constitutional only if it applies to all forms of flag destruction equally. D. The law is unconstitutional because no speech-related acts can be criminalized. Answer. A. The law is unconstitutional because flag burning is protected symbolic speech. Explanation. In Texas v. Johnson, 1989, the Supreme Court ruled that flag burning is protected symbolic speech under the First Amendment. The government cannot prohibit expression simply because it is offensive. Answer B is incorrect because protecting national symbols is not a sufficient interest to override the First Amendment. Answer C is incorrect because even if a law applies broadly, it cannot criminalize protected expression. Answer D is incorrect because some speech acts like truth, threats, or incitement, it can be restricted. Question 18. During the introduction of new methods where coordination is essential, Congress passes a law prohibiting campaign donations from corporations. A corporation challenges the law, arguing that it restricts political speech. What is the key legal issue? A. Whether corporate political spending is protected as free speech. B. Whether Congress can regulate campaign financing in the interest of democracy. C. Whether corporations are considered individuals under the law. D. Whether the law unfairly targets specific political viewpoints. Answer: A. Whether corporate political spending is protected as free speech. Explanation: in Citizens United v. Feck, 2010, the Supreme Court ruled that corporate political spending is protected speech under the First Amendment. The court reasoned that the government cannot restrict political speech based on the speaker's identity. Answer: B is incorrect because while Congress can regulate elections, it cannot impose restrictions that violate the First Amendment. Answer: C is incorrect because corporate personhood is not the primary issue. The issue is speech rights. Answer: D is incorrect because the law's viewpoint neutrality does not determine its constitutionality. Final thoughts. These highly detailed questions and explanations are designed to test advanced knowledge of First Amendment law while also reinforcing key constitutional principles. Question 19. During a comprehensive review of a process that needs improvement, a state government implements a law banning all anonymous political donations to prevent corruption. A political activist challenges the law, arguing it violates the First Amendment. How should the court rule? A. The law is unconstitutional because anonymous donations are a form of free speech and association. B. The law is constitutional because transparency in political funding is a compelling government interest. C. The law is unconstitutional unless it applies only to large donations exceeding a certain threshold. D. The law is constitutional only if it applies equally to corporations and individuals. Answer: A. The law is unconstitutional because anonymous donations are a form of free speech and association. Explanation: in McIntyre v. Ohio Elections Commission, 1995, the Supreme Court ruled that anonymous political speech and donations are protected by the First Amendment. The court emphasized that individuals have a right to distribute political literature anonymously, reinforcing the principle that anonymity is essential for free expression, particularly in political discourse. Answer: B is incorrect because while transparency in elections is illegitimate interest, a blanket ban on anonymity is too broad. Answer: C is incorrect because the First Amendment protects anonymity regardless of the donation amount. Answer: D is incorrect because the constitutional issue is not about equal application but rather the right to anonymous speech itself. Question 20. When improving a process that shows unexpected results, a local government prohibits religious organizations from hosting public worship services in school auditoriums after school hours, even though secular groups are allowed to use the space for meetings. A church challenges the rule. What is the most relevant legal precedent? A. The policy is unconstitutional because it discriminates against religious groups. B. The policy is constitutional because public schools must remain secular. C. The policy is unconstitutional unless the government can show a compelling reason for the restriction. D. The policy is constitutional because it does not prevent worship, only the use of school property. Answer: A. The policy is unconstitutional because it discriminates against religious groups. Explanation: in Good News Club v. Milford Central School, 2001, the Supreme Court ruled that if a public school allows secular groups to use its facilities, it cannot exclude religious groups solely because of their religious nature. This violates the Free Speech Clause because it constitutes viewpoint discrimination. Answer: B is incorrect because neutrality requires equal treatment, not exclusion. Answer: C is incorrect because strict scrutiny only applies if there is a compelling interest, which does not exist here. Answer: D is incorrect because preventing the use of public property selectively for religious reasons is unconstitutional. Question 21. While analyzing inconsistencies across various units in speech protections, a state law requires online platforms to remove content deemed offensive by a state-appointed board. A journalist challenges the law, claiming it violates free speech. What is the constitutional issue? A. The law is unconstitutional because it is overly vague and restricts free speech. B. The law is constitutional because online platforms must follow state regulations. C. The law is unconstitutional only if it disproportionately affects certain viewpoints. D. The law is constitutional because states have an interest in protecting public discourse. Answer: A. The law is unconstitutional because it is overly vague and restricts free speech. Explanation: the First Amendment prohibits vague laws that give excessive discretion to government officials. In Reno v. Eclue, 1997, the Supreme Court struck down a similar law regulating indecent content on the internet, finding it too vague and a violation of free speech. Answer B is incorrect because the government cannot compel private platforms to censor speech. Answer C is incorrect because the law is unconstitutional even if it is neutrally applied. Answer D is incorrect because a state's interest does not override the First Amendment. Question 22. During the introduction of new methods where coordination is essential, a mayor requires journalists covering protests to obtain a press pass from the government. A journalist without a pass is arrested and challenges the policy. What is the like you ruling? A. The policy is unconstitutional because it restricts press freedom. B. The policy is constitutional because it applies to all journalists equally. C. The policy is unconstitutional only if it is enforced inconsistently. D. The policy is constitutional because cities can regulate public safety during protests. Answer A. The policy is unconstitutional because it restricts press freedom. Explanation. In Shuttlesworth v. Birmingham, 1969, the Supreme Court ruled that governments cannot require a permit for protected speech without clear, objective standards. A press pass requirement gives the government too much discretion over who can cover events violating freedom of the press. Answer B is incorrect because equal application does not make an unconstitutional law valid. Answer C is incorrect because the policy is unconstitutional regardless of enforcement. Answer D is incorrect because public safety concerns do not justify prior restraint on journalists. Question 23. When considering past decisions with unexpected consequences, a state legislature bans all political advertising within 30 days of an election to prevent misinformation. A candidate challenges the law. What is the likely outcome? A. The law is unconstitutional because it is a content-based restriction on political speech. B. The law is constitutional because it applies to all candidates equally. C. The law is unconstitutional unless it targets only false statements. D. The law is constitutional because election integrity is a compelling interest. Answer A. The law is unconstitutional because it is a content-based restriction on political speech. Explanation. In Buckley v. Balliol 1976, the Supreme Court ruled that restrictions on political speech are subject to strict scrutiny. A blanket ban on political advertising violates core First Amendment principles. Answer B is incorrect because equal application does not justify content-based restrictions. Answer C is incorrect because even false political speech is often protected. Answer D is incorrect because while election integrity is important, the law is not narrowly tailored. Question 24. During the introduction of a new system for monitoring hate speech, a public university disciplines a student for making controversial political statements on social media. The student sues, claiming a First Amendment violation. How should the court rule? A. The university's actions are unconstitutional because public institutions must respect free speech rights. B. The university's actions are constitutional because hate speech is not protected. C. The university's actions are unconstitutional only if they target one viewpoint. D. The university's actions are constitutional because it has an interest in maintaining campus harmony. Answer A. The university's actions are unconstitutional because public institutions must respect free speech rights. Explanation. In Healy v. James 1972, the Supreme Court held that public universities cannot restrict speech simply because it is controversial. While hate speech is offensive, it is still protected unless it constitutes true threat or incitement. Answer B is incorrect because hate speech is generally protected. Answer C is incorrect because targeting any speech based on viewpoint is unconstitutional. Answer D is incorrect because campus harmony does not override the First Amendment. Final thoughts. Question 25. During an evaluation of a new approach that differs from previous methods, a state law prohibits individuals from protesting within 50 feet of a government building where lawmakers are conducting legislative sessions. A group of activists challenges the law, arguing it violates their First Amendment rights. How should the court rule? A. The law is unconstitutional because it restricts speech in a traditional public forum. B. The law is constitutional because the government has a compelling interest in preventing disruptions. C. The law is unconstitutional only if it applies selectively to certain groups. D. The law is constitutional because reasonable time, place, and manner restrictions are allowed. Answer D. The law is constitutional because reasonable time, place, and manner restrictions are allowed. Explanation. In Hill v. Colorado, 2000, the Supreme Court upheld certain buffer zones around specific locations, ruling that reasonable restrictions on time, place, and manner of speech can be constitutional if they are content neutral, narrowly tailored, and serve a significant government interest. Answer A is incorrect because not all restrictions in public forums are unconstitutional provided they are content neutral. Answer B is incorrect because a compelling interest is not necessary for a content-neutral restriction, only significant interest. Answer C is incorrect because law does not need to be selectively applied to be unconstitutional. Even broad restriction can violate free speech if not properly justified. Question 26. When assessing a newly introduced process that contradicts previous practices, a public university establishes a policy requiring students to obtain prior approval before distributing political leaflets on campus. A student is denied approval and challenges the policy. What is the most relevant legal principle? A. The policy is unconstitutional because prior restraints on speech are heavily disfavored. B. The policy is constitutional because universities can regulate student conduct. C. The policy is unconstitutional only if it affects one political viewpoint more than others. D. The policy is constitutional because students must follow institutional guidelines. Answer A. The policy is unconstitutional because prior restraints on speech are heavily disfavored. Explanation. In Neer v. Minnesota, 1931, and Freeman v. Maryland, 1965, the Supreme Court ruled that prior restraints on speech, rules requiring government approval before speech occurs, are presumed unconstitutional. In the case of public university, the institution is bound by First Amendment protections and not require pre-approval for speech activities. Answer B is incorrect because while universities can impose some regulations, they cannot require prior approval for protected speech. Answer C is incorrect because the policy is unconstitutional regardless of viewpoint discrimination. Answer D is incorrect because institutional guidelines cannot override the First Amendment. Question 27. During the introduction of a method aimed at improving social harmony, a city enacts an ordinance prohibiting offensive speech in public parks to prevent conflicts. Comedian is fined for making political jokes and they challenge the ordinance. What is the likely ruling? A. The ordinance is unconstitutional because it is overly vague and gives the government too much discretion. B. The ordinance is constitutional because the government can regulate offensive speech in public spaces. C. The ordinance is unconstitutional only if it is applied selectively to certain individuals. D. The ordinance is constitutional because the government has an interest in preventing disturbances. Answer A. The ordinance is unconstitutional because it is overly vague and gives the government too much discretion. Explanation. In Coates v. Cincinnati, 1971, the Supreme Court struck down an ordinance that banned annoying conduct in public spaces because it was unconstitutionally vague. The First Amendment prohibits laws that are too vague as they give the government excessive discretion to decide what speech is prohibited. Answer B is incorrect because offensive speech is generally protected under the First Amendment. Answer C is incorrect because a vague law is unconstitutional regardless of whether it is applied evenly. Answer D is incorrect because maintaining public order does not justify broad speech restrictions. Question 20. When considering the unintended consequences of new legal interpretations, a state requires all social media platforms to remove posts containing false information about elections. Political commentator is banned from platform and challenges the law. What is the constitutional issue? A. The law is unconstitutional because it imposes government control over speech. B. The law is constitutional because misinformation is not protected by the First Amendment. C. The law is unconstitutional only if it disproportionately affects one political party. D. The law is constitutional because election integrity is compelling government interest. Answer A. The law is unconstitutional because it imposes government control over speech. Explanation. In United States v. Alvarez, 2012, the Supreme Court ruled that even false statements are protected by the First Amendment unless they fall into specific unprotected categories e.g. fraud, defamation, incitement. A law requiring platforms to remove false election information gives the government broad authority to censor speech violating the First Amendment. Answer B is incorrect because misinformation is generally protected unless it causes direct harm. G. Fraud. Answer C is incorrect because the law is unconstitutional regardless of whom it affects. Answer D is incorrect because while election integrity is important, banning speech is not the least restrictive means of achieving that goal. Question 29. During the implementation of a program designed to prevent disruption, a high school principal removes an article from the school newspaper that criticizes the administration. The student editors file a lawsuit. What is the likely legal outcome? A. The censorship is constitutional because schools have broad authority over student expression. B. The censorship is unconstitutional because public school newspapers have full First Amendment protections. C. The censorship is constitutional because school-sponsored speech can be regulated. D. The censorship is unconstitutional unless the article contained false information. Answer C. The censorship is constitutional because school-sponsored speech can be regulated. Explanation. In Hazelwood School District v. Kuhlmeier, 1988, the Supreme Court ruled that schools can regulate the content of school-sponsored newspapers as long as their actions are reasonably related to educational concerns. However, this power does not extend to independent student speech outside of school-sponsored activities. Answer A is incorrect because schools do not have unlimited authority over student expression. Answer B is incorrect because school newspapers do not have the same First Amendment protections as professional media. Answer D is incorrect because truthfulness is not the issue. School-sponsored speech is subject to administrative control. Question 30. When re-evaluating a process that has been used inconsistently, a city requires street performers to apply for a permit before performing in public spaces. A musician challenges the requirement. What is the likely constitutional ruling? A. The permit requirement is unconstitutional because it serves as a prior restraint on free expression. B. The permit requirement is constitutional because cities can regulate public performances. C. The permit requirement is unconstitutional only if it is applied inconsistently. D. The permit requirement is constitutional because it applies to all performers equally. Answer A. The permit requirement is unconstitutional because it serves as a prior restraint on free expression. Explanation. In Lovell v. City of Griffin, 1938, the Supreme Court ruled that permits for public expression are unconstitutional if they give officials broad discretion to approve or deny speech. A permit requirement for street performances functions as a prior restraint and is presumptively unconstitutional unless narrowly